part of the classification. And then there are other types of so-called incentives that we administer as well, which include the Affordable Housing Special Assessment Program, and we will be going over a little bit about that as well today. And then we also, of course, on a day-to-day basis as a public body that is here to serve the public, we assist taxpayers on a daily basis and answer a lot of questions that revolve around these rules and just the work that we do on a daily basis. So how does the system work, this cycle? As a lot of you know, it starts with the levies. All of the municipalities in Cook County, budget what how they're going to be funding the local services that are offered in their respective municipalities, and they file those with the Cook County Clerk every year. And the levies are published on the Cook County Clerk's website. The assessor assesses, or well, if I'm going in the order of the screen here, the local tax rates are then set by the Cook County Clerk's office. So they basically take those levies, they divide them by the equalized assessed values, and then you would ultimately get they would come up with the tax rates, and then the tax bill would be issued by of course, the Cook County Treasurer's office to distribute to the taxing districts. And then the Cook County Assessor's office is the one that is setting those assessed values and then the equalized assessed values as well. And so everybody has their respective roles in the property tax system, including, of course, the Illinois Department of Revenue, who sets the equalizer every year, which is the multiplier by which which also is a part of the calculation for coming up with your tax amount due on the tax bill. So assessed valuations in Illinois, county assessors assess, of course, at fair market value, but we also have to assess properties uniformly. The uniformity requirement is a constitutional mandate of the Illinois Constitution. And so what we're doing, as we like to say, is view the properties. We're looking at the entire forest of trees. We're not just looking at the single tree. So we assess properties on what's called a mass appraisal basis. As I've said in jest before, because levity is the way that I operate, is that the assessor is like the Lorax. He speaks for the trees, but he speaks for all of the trees. And we only look at the single trees when you appeal to our office. But in order to achieve both uniformity and fair market value, this is how we do it. We do it on a mass appraisal basis because, as I mentioned earlier, we do have 1.9 million parcels of property, and it's very difficult to assess individual properties when you have that many to deal with every year. Because we're doing this on a mass appraisal basis, and it's a computer statistical model that we use, and it's a data-driven model. We post our both residential and commercial models are on our website, and you can go there and look at those. And I'm going to go through all of that with you. So on our homepage, cookcountyassessor.com, there is a tab at the top for data, and you go down there and you'll find the valuation reports. You'll give me a moment. I'm going to also change my screen here, but I'm going to go through the data that I mentioned first, the valuation reports, and then from there you find our reassessment methodology worksheets. For income producing properties. These are the methodology worksheets that we publish for all of the triennial townships every year. So you wouldn't find methodology worksheets for any of the City of Chicago townships this year because we reassessed the City of Chicago in 2024. But we do have the historical, the previous year's worth of methodology worksheets on our website. Then we also have the Assessor's 2023 Open Data Refresh, which is part of the open data portal, but I have also provided here the direct link to the open data refresh, as opposed to trying to navigate from the data portal, which you can do. But this is just easier if you bookmark it. You can go there and there's an enormous amount of data on there. And then I'm going to go through what the assessor just affectionately calls the public access channel, if you will. And it offers you a lot more details than the traditional or the customary property detail page that you're used to seeing. And so I'm going to kind of go through that a little bit with everybody today and show you what to do. So I'm going to just stop sharing here and share different screens so that we can do that. You'll give me a minute. Okay, let's see. Oh, here we go. I got it. All right. Everybody sees the correct screen. Can my co-presenters want somebody give me a thumbs up? Thank you, Michael. Okay, good. So here's the assessor's homepage. And as I mentioned, you go to the data tab at the top here and click on valuation reports. And here's where you will find, of course, this beautiful map. It's an interactive map, and you can click on that map if you like. And it gives you the step-by-step how to, find what you're looking for. And these are currently the all of the townships that we'll be reassessing in 2025. You won't find anything on there just yet for those, but if you go to 2024, you find City of Chicago reassessment townships, and everything is grouped, of course, by residential and commercial. When you go click on, say, Rogers Park Township Commercial, you find here the methodology worksheets. And get familiar with these. I know a lot of people have said how much they really love having these at their fingertips when they need them, because it gives you all of the inputs that we're using in our model to value these income producing properties in Cook County. There's a wealth of data. You have to navigate also at the bottom with the various different tabs, and you can see which property classifications are included in those tabs: the condos, the industrials, multifamily, gas station, hotels. Try to keep everything as organized as possible so that it's easier to find. And then, of course, by the key pin. And then when there's a key pin that's has multiple pins associated with it, you can see those as well in the next column. But you should love these because they're great. We're basically telling you exactly how we valued your property on a mass appraisal basis. And this should really help guide you to determine whether or not you need to file, or whether your client wants to file an appeal. So there's that. Then going back to the home page of the assessor's website, the data tab, if you go down here, there's this link for the data sets on the Cook County data portal. Do you see this? Are you seeing the screen correctly? Okay, great. So if you were to navigate from here to go to the open data refresh, which you can do, and it's right here, Assessor 2023 open data refresh. And from here, of course, there are multiple data sets that are really helpful, and it will tell you what each data set contains. The parcel universe, of course, contains data for all parcels in county, and it goes back to 1999, and it tells you exactly what is included in that data set. Some of the more popular ones are the assessed values data set, and then appeals is another popular one as well. But there's really, and the property tax exempt parcels too will tell you all of the parcels with a tax exempt status. And these can then be filtered out. So you can go to assess values and you filter out your data by clicking actions and then query your data. And then you can query it by tax year. Select a tax year. You have to change the conductor, and you can say, type in 2024. But you have to click apply in order for it to apply. And as you can see in this column here, tax year, it's changed it to 2024. To add additional filters, you'd click add. You can do it by class. If you want to add multiple classes, you would just select is one of as the connector. If you want to do a single class, you just do is and save, put in a 278. It does not take hyphens, so don't put a hyphen in to find your classification. Sometimes it is a little bit slow to run, but just be patient with it and you will come up with the correct. Sometimes it's a little finicky. But you have to click apply each time and see this little green arrow to know that that filter was applied to your query. And then you would export whatever it is that you're looking for, and it will produce a CSV file for you. pretty simple at first, and then even simpler as you like kind of toy around with it and practice with it. So you can get yourself a file. And then, so that's the data refresh. And then going back to the assessor's homepage again, and you go back down to the search bar, you would type in, let's say you type in a PIN number. This is for the public access channel. I'm just typing in, and don't forget to do the CAPTCHA, otherwise it will tell you no, you can't go forward. And you'll get the property details page, which most people are pretty familiar with if they've navigated our site before. But the public access channel is this button here that says access more in-depth property details here. And you click on that. And right now it is set to the 2025 assessment year. So you're not going to get a whole lot of information for this PIN. Did I change it? If you want to get information for a prior year, actually, you know what? Let me use a different PIN number. So you go to this button at the top, and I like to do it by PIN number. You can do it by address, but PIN is easier. I'm going to put in a different PIN because that one did not give us much. And then to change the year, if you want to look at a prior year, you have to select the tax year here. So you can go to 2024 and then click search. And then here you'll find the information for this PIN. You can find out if there were any appeals or C of E's in this PIN in 2024. You can see here appeal results, no change, and what the reason code was, what it was. You can add if there were any permits, if there were any recent sales. In this case, there was a recent sale that was recorded. So that's how you navigate that. If you want to look at prior years, you just have to go and type in the PIN and then select the year, and you can go to 2023 and see if anything came there. But I know that that was not something that was not entirely intuitive to most people, so hopefully that will be very helpful to you. Okay, so moving on back to okay. All right. So as I mentioned, there are multiple data sets on the data portal that you can navigate and find really an enormous amount of information. And that kind of concludes my little demonstration for you. And I'm going to pass this along to Gina.
Hello.
Sorry. Gina,
that's all right.
Thank you.
Okay, so we do have a lot of information on our website about appeals. It's not just the appeal rules, the appeal guidelines in this video. We try to make it as easy as possible for everyone to get as much information as you can. You can go to our appeals overview page by simply going to our website and navigating down to overview. I'm not going to do a live demonstration of this, but it gives you information and links like, should you file an appeal, where you can find various different information, reasons for why maybe your most recent sale price and your assessment don't line up, whether or not you need to hire someone to file an appeal. The answer is no, you don't, not at the assessor's office. But anyway, I'm going to move on now to a few key things about assessment appeals.
Gina, I'm sorry to interrupt you, but I just want to make this clear really quick because I see quite a few people in here raising their hand. I just want to let people know we're not using the raise hand feature. So if you have a question, please drop it in the Q&A, and one of our experts will help you out because I see quite a few people. Sorry to interrupt you. Go ahead.
That's okay. Thank you, Angelina. And this is information that you'll kind of get from our appeals overview as well. But there's a lot of misunderstanding about what an appeal is. What you are appealing is the current year assessment, not your tax bill. Once you get your tax bill, it is actually generally too late to file an appeal for your assessment. So when you You need to file your assessment once you get that assessment notice or once we open up the calendar for assessments for your township. So again, just want to reiterate, it is the current year assessment that is appealed and not the tax bill. Past tax years can be addressed through a certificate of error, but not with the current year appeal. Change in assessed value doesn't always equate into a reduction in the tax bill. There's a lot of things that go into the tax bill. The assessment is just one thing. There's also the levy is set at the beginning of the year. We already showed this graphic, but yeah, levy's set at the beginning of the year. And the tax rates are based on levy. And then also we have the state equalizer, and also any, for residential property, any kind of exemption that you have will also affect your tax bill. Just again, as a note, for those who may not might be new to this meeting, the assessor does not calculate, mail, or collect property tax bills. That is under the Cook County Treasurer. And so for our appeal rules, major reorganization this year. We've completely reorganized them to improve its flow, readability, appearance, navigation. Many of the old familiar rule numbers have changed, along with the location of some familiar information. We did this because not only have we added some new rules, but also in the prior versions of rules, we had some really long paragraphs that had a lot of information packed into them, and they could be hard to read, easy to miss things. We don't want it to be hard to read and easy for anyone to miss anything. There's a lot more white space, a lot more headings, so hopefully they'll be easier for you to navigate. We do ask that everyone review our appeal rules and also the appeal guidelines and any information on our website that will be helpful to you, like the overview, the valuation reports, and other things that Christina showed to you before filing your 2025 appeals. That way you can make your appeals better or decide maybe you don't even need to file an appeal. Our appeal rules and appeal guidelines are posted on our website, and that's the website right there, but you can easily navigate to it as well. So this is to start our whirlwind tour, and don't worry that I'm going through them kind of fast because we're going to go into these some of these in more detail later, but I just kind of want to give a general map here of where things are. And then also you can always, once the slideshow is sent to you, or made it so you can download it, you'll have a quick little map of where everything is. But our first section of the rules, general provisions, rule 1 is basically the one that says, please follow our rules. Please follow our appeal rules. We look for substantial compliance. We don't look for absolute perfect compliance. And then just know that no matter what, your assessment appeal is always subject to review. You might follow every last rule, but we simply do not agree that there is a reduction. And that's okay, because you can always go to the Board of Review if you are unhappy with our decision. Forms and documentation, general provisions. The main thing we ask is please make sure all the forms you give to us in support of your appeal are legible and complete. Also, please redact all non-public personal information like a social security number, bank routing numbers, bank account numbers. Please don't make that information public, either on yourself or on behalf of your client. Just redact. Our appeal guidelines give good instructions on how to redact. Property inspection requests. If you ask for a property inspection and then we say, yeah, we do need to send somebody out in person, please do not block our investigator from our inspectors, our field inspectors from being able to review your property. They're generally going to review the outside unless some kind of prior arrangements have been made. But if you block them from being able to conduct your field request, we can't really do the field check. And then we haven't really had homestead exemptions in our appeal rules before because they're completely separate processes. However, sometimes people get confused and they commingle the two. Please don't commingle your homestead exemption application and your assessment appeals. Doing so really delays you getting the homestead exemption, which nobody wants to happen. All right, next step. So The next section is filing assessment appeals, representation, and deadlines. Appeal filing in general, an appeal is started once you file it and hit that submit button in Smart File. We highly encourage everyone file electronically rather than with paper. But yeah, your appeal is started when you file it. Attorney and agent authorization. Taxpayers may hire an attorney or other representative to help them file their appeal. That's fine. But there is a form that just says, I have authority from the taxpayer to file this. So it talks about that form and what needs to happen. You don't have to hire an attorney, but you can at the assessor level. The first appeal is the controlling appeal. Whoever's first in time for a particular PIN is the appeal. That's the controlling appeal. Sometimes something happens, like somebody makes a mistake in entering a PIN, or maybe there's an accidental double docket, or sometimes taxpayer will determine, I meant to hire attorney B instead of attorney A, or I didn't even want to hire an attorney. Okay, well, you can substitute. And Rule 8 gives the rules on how to do that. Rule 9 is the anonymity requirement. Basically, if you are representing somebody else, as most practitioners already know, you have to give two separate set of documents, the anonymized one and the non-anonymized one. That's hard to say. That's to prevent any kind of bias in the, we're just trying to prevent any kind of bias in the appeal review period. We want to make sure that, everybody's on the same level playing field. Appeal deadlines. Our deadlines are hard deadlines. We don't have a separate appeal. We don't have a separate evidence submission period. When that date on our website comes and goes, that's it for your appeal filing. You can't add to it. We have some exceptions for when there's a technical error on our side, and Rule 10 talks about that, what you do. However, generally, our deadlines are deadline. And if you miss our deadline, there's no reason to despair. You can still go on to the next level of appeal to the Board of Review. So, and then Rule 11 is some more miscellaneous rules. They had appeared elsewhere previously. Basically says brief is helpful. Tell us what you think the estimated fair market value is. And one of the most important things this rule does is what happens when your appeal covers more than one PIN? What do I need? What do I list first? How many can I list? So on and so forth. This rule talks about what to do when you have multiple PINs, along with a few other fun things, but you can read the rule and see what all it talks about. Next section. So evidence in support of an assessed valuation appeal. So I'm not going to talk about the specifics of each of these rules right now, but we are covering some of those in more detail a little bit later. I just want you to see where things are. Supporting evidence for all appeals. That's the main thing here is colored photographs. Your appeal, make sure you have colored photographs covering the lien year of the appeal, and that they're in color and they're dated, and that they're legible, they're not all blurred, they're of the property. We have seen many instances of Google photos that are not even of the correct property. You don't want that to happen. That doesn't help you. Rule 13, purchase and sale agreements and documentation. I mean, of course, the three we always want are deed, purchase and sale agreement, and the closing statement, but it also gives more details. Appraisals should be credible. And we will talk more about this rule specifically in a bit. Rule 15, we've never had a comps rule before, and it's one of the most common reasons that people appeal their residential assessments. So we have a rule now telling, what to do in a comps appeal. And then also there's more detail covered on comps, how to select comps in our appeal guidelines. Rule 16, income producing property. Now, we still get requests from some people saying, hey, I'm waiting for my RPI code. You don't need an RPI code. RPI, all that information, the income information is built into Smart File. So just answer the income questions in Smart File. You don't need an RPI code. You're not going to get an RPI code. So Rule 16 talks more about that, as do the appeal guidelines, and then, past meetings that we've had talking about this. Rule 17 covers condominium and townhomes, including common area. There is specific documents we like to see for common area appeals that are often missing from such appeals. We've never had a rule before on land valuation. We do now. We put all the stuff that used to be everywhere else kind of together. So, and also we're talking about our new policies here. So we have a new demolition policy that we will talk about a little bit more later, but that's under Rule 18. Rule 19 covers ongoing construction. How do I appeal something that's undergoing construction? Rule 19 will talk about that. Rule 20 is still vacancy. It's still the same thing. So that hasn't really changed. And it's in the same spot. Rule 21 is class change request, covers all kinds of class changes within class 2, class 5 to 212, 5 to 318, and we will talk about changes to 318 a little bit later. Class 4 is not for profit, incentive classes, non-incentive classes. There's links to information on the Affordable Housing Special Assessment Program, which we'll talk about a little bit later, and also the low-income housing tax credit. Rule 22, we haven't had one on omitted assessments before. We do now, and we're going to talk about that a bit more later. Rule 23, before we had a very short rule regarding property tax exempt properties. It's just more expanded now, and we'll also talk about that a bit more later. Just as a note for those who may not know, but property tax exempt properties are those owned by churches and municipalities rather than your homestead exemptions. So please don't get those confused. All right, and so the final section of the rules in our whirlwind tour is Rule 24. There's still no appeal re-reviews. Corrections of factual errors. How do you do that? It's covered by Rule 25, and I will also talk about that a little bit later in the presentation. But factual errors are things like building square footage, number of bedrooms. Sometimes we make a key punch error. Those are all factual errors. Rule 26 covers what to do when you have a property location correction that you need. And I'll talk about that a little bit later in the presentation. Rule 27 is certificates of error. We had rules for it before, but we've expanded them some. So now that whirlwind tour is over, I'm going to turn the presentation over to Michael Piper, our Chief Valuations Officer, to talk more about some of the different types of evidence that we require in an appeal.
Thank you very much, Gina. Appreciate it. That's a lot of information, and you went through a lot of rule numbers and a lot of what it is we're going to talk about a little bit more in detail. And we're going to start with appraisals. So for residential appeals, we don't see a lot of appraisals. For commercial appeals, while they're not necessary, an income and expense statement is good and appraisal is better. But when you send an appraisal in, there are certain things we're looking for. And at the top of that list, you see must be credible under USPAP standards. Now, if you're an appraiser or if you've hired an appraiser to do your appeal and submit it, that appraiser knows what USPAP means. And I say that to say that our analysts are not going through your appraisals trying to figure out if it's not USPAP standard, up to USPAP standards, but your appraiser would know if it's not. And I'm going to leave it at that, because if it's not, we don't consider it credible. Gina mentioned color photographs, and you'll hear that as a repeated theme. For evidence for us, color photographs, dated color pictures are the best. We can take a picture, go on social media, go on Google, you can take a picture of just about anything, any property, and that's fine, but we're looking for dated pictures. We want all pins to be included in the appeal, and that could be burdensome sometimes. Typically for residential, again, one pin usually covers the entire parcel, but for commercial properties and industrial, sometimes there may be 5, 10, 20. I've seen up to 80 pins cover one particular property. I won't mention it, but it's one of the arenas in the Chicago area. It must be based on available and reasonable sales and market data, okay? And when we say cherry-picked, usually comps that are included in an appraisal will bracket the subject, but they're not all going to be lower value or lower assessment. They shouldn't be cherry-picked. And finally, the filer must provide any other appraisal that was completed over the past 2 years, just to make sure that we're all on the same page. If one was done for another reason, that's fine. If one was done for appeal reasons, that's fine too. It should be included if one was done. When we say comps, what are we talking about? We're looking for something, a property that's not necessarily exactly like the subject, but something in which it's in a similar or close location, similar size. Again, we mentioned that theme of not cherry picking the comps that just make your point. We understand what the job assignment is, and that is to convince us that our value is not uniform or too high. We get it, but we want to make sure that the comps that are being presented to us, to the analysts, are credible. Ideally, we would like to see 5 comps, but at least 3 comps to make the point. Again, color pictures with dates on them, and it should include your appeal should include every pin, just like your comps should include, your pictures of your comps should include the pin that you've taken a picture of, okay? If you're using sales comps, make sure that each one of the sales is an arm's length transaction, not a compulsory sale. Unless the property is very different, very unique, we're not concerned with things like swimming pools. And that's because, does the swimming pool add value? Usually, but not always. How much value does it add? That sometimes is hard to quantify within any particular area. And finally, anything that we wouldn't normally see, like paint job, interior, updates to the kitchen or the bathroom, we're not interested in that. These are the most important factors in choosing comps that you want to present to us to hopefully change our opinion of what the property is worth, okay? If the subject property is in one area, we're looking for the comps to be either close by or in a comparable area, but ideally close by, because if it's not in the same location or somewhere close by, we're going to have to figure out if the location is comparable. So you want something that's close to the subject property. We want the area to be a similar size. The square footage should be similar. The age, we use a different definition of age. If you notice, number 3 does not say year built, okay? If the subject property was built, let's just say mid-20th century, 1940, 1950, and the comps that you're providing were also built at that same age, but the subject property was gutted 2 years ago, the effective age is 2 years to us. So we're looking for something of a similar age. Effective age is more important than actual age to us. The exterior construction, that's typically something that does not change even though the property gets older. If it's masonry, you want to compare it with a masonry property. If it's frame, your comp should be frame. The basement, again, if you have a finished basement, you don't want to bring a comp in with a slab or crawl or an unfinished basement, because we're not talking the same language. The square footage of the land should be something similar to the subject property. And finally, with garages, you know, you're going to compare a 1-car garage with a 1-car garage, a 2-car garage with a 2-car garage. We want to make sure we're talking apples to apples. And when we say similar, again, doesn't have to be exactly the same size, but you're not going to bring me a ranch in and tell me this is a comparable property to a 5-story subject, okay? And you can see in the pictures what we mean by similar.
Yeah.
Okay. Land valuation, rule number 18, land valuation, classification, and demolition. So kind of related topics here. I don't know who that is. I hear it, but I'm going to ignore it if you guys can. It might be in your area, Brian. You might want to mute yourself. There we go. Great. Thank you. Sometimes assertions on appeals, assertions that the land is overvalued or not uniform can be based on one of the following things. Sometimes it's incorrect because the square footage that we have is different from the actual square footage, and that's possible. We're 1.9 million parcels. We may have that information incorrect. Sometimes the land should be valued as farmland, which everywhere in not only Cook County, but in Illinois and in most places, farmland is valued at a much, much, much lower value than other types of land. If the land on the subject is excess land, surrounding yard, or unbuildable, we want to know that. Okay, these are all reasons that an appeal might come in on the land itself. Unimproved land due to demolition, residential, commercial, or industrial. Okay. If your property is, or the land itself is susceptible to flooding with hard rain, you want to point that out to us. However, if it's already included as part of a FEMA floodplain map, usually that's already incorporated and factored into the value. No need to file an appeal just based on that reason alone. Okay. We don't independently check the land square footage for any particular pin. Okay. Remember, with land square footage, what we're doing is we're looking at your appeal and we're looking to see why is our number different from your number. And if the land square footage is different from what you're telling me it is, we consult the county records. If the county records line up with what we say, that's usually good enough for us. Now, sometimes the county records might be wrong also, in which case, and this is what this slide is basically telling you, you want to make sure you check that county map, and you may need to check with the clerk's office, the clerk's mapping department, and bring some actual physical evidence to show a survey or something like that to show what the county is showing as 5,000 square feet should actually be 2,500 square feet. There's any number of reasons why the county's records could be different from what your actual land square footage is. Okay, farmland, as we mentioned before, if your land should be classified as farmland, that I won't go into all the details of what makes it qualified. Typically, it's something that's been used as a farm for the prior 2 years, 2 years prior for the year in which you're appealing it. You'll need to be able to document that. If that's the case, we will then reclassify it as a 239. And if you go to the website, and the website URL is right here, you'll see what our updated policy is regarding farmland. Please review this. So also under Rule 18, unimproved land due to demolition. Now, a lot of appeals that we see regarding what should be classified as unimproved land has to do with something that took place mid-year. And we want to make sure that we're factoring in when the demolition took place. So we need something, a demolition permit showing the date of the permit issuance. Unless the property, the improvement just happened to fall down and collapse, which we know that happens occasionally, but if it was an intended demolition, a demolition permit was acquired by the developer or the owner of the property. There should be some payment for the cost of demolition. We want to see that. These are all things that kind of speak to the fact that it was demoed legally, it was demoed at a particular time. There's a color picture that you want to submit us. Again, there's that theme of dated color pictures as opposed to what you can just get off of Google. An affidavit stating the date of the demolition when it took place. And then you're showing me all this, but then tell me what you're showing me. A narrative providing information regarding the demolition with all those key dates that we just mentioned. Okay. And again, as I said at the beginning, if this was something that took place mid-year, we will factor that in and prorate the valuation based on when the demolition took place. So we may assess the property as if it's improved, but at the point where the demolition took place, we will value it as unimproved, as demolished. Okay. Regarding the demolition, and I just explained this to you kind of briefly, but there's a more detailed updated policy on our website, and you can see that here. It talks about what we do mid-year or at the beginning of the year, what type of documents should be submitted to support your appeal, that something should be classified as a class 100, which is, 10% level of assessment and vacant land. And if that's what you're looking for, take a look at the policy. It's been updated recently. Related to this, Rule 19, ongoing construction. Again, a lot of the appeals that we get have to do with something that took place mid-year, and you want your assessment to reflect the fact that construction took place, but wasn't necessarily completed in that particular year. So again, take a look at the website. The updated policy is on there, but it explains our approach to valuing new construction. We're looking at basically the finished property, what the value of the finished property would be. We make an assumption based on when it was finished, but we look at, documents, construction schedule, okay? Was that schedule adhered to? Pictures, okay? If we need to come out and take pictures, we can do that, but we want to make sure that the value is factoring in when the construction was completed, when a certificate of occupancy or something like that was issued. And that way we know we can go ahead and put the entire finished improvement on the books for the rest of the year, okay? So we're going to move on to Rule 21 and really some other details of class change request, and Tasha's going to talk about that. But just in general, when you're looking for a class change request, again, there's that theme again, color photographs, can't stress that enough, with the date, and tell me what it is I'm looking at. To support that, building details, floor plans, surveys, appraisals, use PAP compliant appraisals. Any document that shows the building's use, current use, commercial, residential, mixed use, leases and rent rolls are always useful. That's something we can't go to CoStar necessarily and get copies of leases and rent rolls. So when you send that in support of an appeal, that's very useful to our analyst. The characteristics for residential and commercial units. How many rooms? What's each room used for? And what's the size of the room? Zoning for residential units, it should be zoned for residential use. Same thing for commercial and industrial. Okay, so I'm going to introduce our Chief Legal Officer, Tasha Gibbons. Tasha is going to talk about something that was a little controversial last year, but having to do with changes to the 318 class.
Okay, first of all, can everyone hear me okay?
Ken.
Great. Okay, so the 318, after an initial attempt to modify, we went back to the drawing board and worked on what made sense in view of both reliance on the way the 318 class had been applied previously and listening to feedback from different parties involved. And with that, this is the revised 318 subcategory that we've put into place. So, and this also will apply in back and look at some values that were should have fit within this new definition for 2020. But for 2025, this is it. So all mixed use commercial residential buildings under 20,000 square feet, but that have 7 units or more, that fits within the category. And then those that are 20,000 up to 99 square feet with no more than 60% of the building use.
Hi, Tasha, I'm sorry to interrupt you. You're just coming out a little fuzzy, robotic. Does she sound like that for anyone else on here?
Yeah, it's and I don't know, I'm sure you tried to adjust that, Tasha, but
My laptop
this-
is having an issue and I tried to restart right before the meeting. So let me walk down and I can work with Christina. So if you can give me a minute, I will be right.
Okay, thank you everyone for your patience. And her office is right down from Christina's, so it'll only take maybe 30 seconds here.
Office sharing. Hold on, I gotta open my trash. Oh, I wasn't sure. I just said, yeah, go for it, yeah.
All right, there we go. Problem solved.
Great. Can you hear me now?
yeah,
Yeah.
Okay. I don't know where the camera is, but I'll do my best. Okay, so anyway, now the revised subcategory does include those that have no more than 60% of the building for commercial purposes. We heard from those who, made investment decisions and all of that based on the prior class 3 definition. So that's where things landed for mixed use buildings which do not meet these parameters, or those for class 212, the building will instead be a split class. So if it's 100,000 square feet and above, then that will include both the class 3 and then likely the appropriate category of class 5. Just click on the screen. Okay, next up are incentive and class 4 not-for-profit. So the class 4 not-for-profit, of course, is also governed by the county ordinance. And we have a updated eligibility bulletin that's available with filing requirements. But these rules have been in effect previously, so that should not be much of a change for you. And then there is an affidavit form that's available on our website. Other incentive classes, there's the eligibility bulletins and information on our website as well under incentive and special properties. And then we have separate information all dedicated to the Affordable Housing Special Assessment Program, which was created at the state level and has been in effect for several years. Can talk a little bit more about that, but there's information available. And then also I know that someone had asked about the affidavits, the annual affidavits, and those will be available soon and can be submitted online. But for ASAP in particular, the affordable housing, this has been, the law is working as it was intended. It's really promoting the development of affordable housing and mixed housing. So because of these different tiers, there's different benefits that can be gained. So developers are making decisions based on that. But if you're tier 1, the property would receive a 25% reduction in the assessed value. And that means that at least 15% of the property through 34% of the dwelling units must be maintained as affordable units. Okay. And there's certain requirements such as meeting the affordability level at or below the 60% of the AMI, and meeting the required rent and income limits. And those are published by IDA, the state organization, Illinois Housing Development Authority. The second tier, of course, even a better reduction, the 35% reduction in the assessed value, and that's at least 35% of the dwelling units must be maintained as affordable units. And then there's annual submissions for those. And of course, our resident expert, Jerry Marconi, is available in the chat box, but also is available at the assessor's office to provide additional input on these. And then finally, the low affordable community, we have fewer of those, but to qualify, there must be at least 20% of the dwelling units maintained as those affordable units, and it has to be a designated low affordability community. Okay, so just to give you a hypothetical example of the ASAP savings, most of you are doing this on a daily basis and can quickly calculate that type of reduction. But for those who are either newer or curious exactly what it looks like, if we were talking about an apartment building with a $3 million market value, just as an example, then with the reduction at the first tier, that 25% reduction, that takes it down to 2.25 million after that reduction. The original tax bill would have been 61,700 and change. And then that adjusted bill, because of that benefit, is $46,279. So you see the savings that happens. This is based on a prior 2022 equalizer and tax rate. It could be different for each year with the tax rate, but the savings is that percentage, based on that percentage reduction. So it's helpful to think about that. I know that, there's changing markets going on out there, but it does seem to be both a need for the affordable housing and interest in development when this incentive is available. Second tier, 35% reduction. Here's an example. You start with the 5 million market value. That's a significant reduction after that 35%. The original tax bill would have been just over 100,000 at 102,841. And that adjusted bill is 66,847. So you see that significant almost $36,000 in tax savings, again, based on those noted assumptions. But that's what we have with the ASAP program. We also have several people that work on it regularly and can provide answers and help, because there's a lot of details laid out in the statute. It was originally following the Class 9, but once the level of assessment changed, there was less benefit from the Class 9, and a number of partners in the private sector that were interested in promoting affordable housing, as well as our office, worked together to try to come up with something that would work. And it seems to be doing that. We have a number of applications still coming in, and this seems to be something of interest to developers as well. And I believe next it will be Christina talking about omitted assessments. So I'll turn the chair back over to her and see you again shortly. Thanks.
Thanks, Tasha. Some great data on affordable housing. And now everyone's absolute #1 favorite in the whole entire world topic, omitted assessments. So we crafted this rule because omitted assessments are just a very niche little thing and oftentimes misunderstood, I think. But basically, the property tax code authorizes the assessor to assess property that was omitted from the tax roll for some reason. Most of the omitted assessments that we issue are typically the result of a transfer from an exempt property owner to an owner who is no longer using it for exempt purposes. And so they, and oftentimes because of the timing of when we are notified about these, that we end up having to issue an omitted assessment. But that's not the only reason. I mean, there are other reasons for issuing omitted assessments, but once upon a time, omitted assessments many years ago, could issue omitted assessments going back in time as far as the assessor wanted. I would say about maybe 11 years ago, the statute changed. It was amended to limit the issuance of omitted assessments to not more than 3 years prior to the current year that we are issuing the omitted assessments on. So the Rule 22 for the omitted assessment process is essentially you're going to be submitting the same types of documentation to our office and to support an omitted assessment appeal. Those same rules apply in a current year. And as I mentioned, the omitted assessments are, of course, limited to 3 years prior to the current warrant year. The warrant year is just basically the current year, right? So if I'm issuing an omitted assessment in 2025, the warrant year for that omitted assessment is 2025, but I may be back taxing the 2024 year, the 2023 year, and at most the 2022 tax year. But you can only appeal your omitted assessments in a current warrant year. That's it. Beyond that, it's just like any other, prior year correction. You would have to then file a certificate of error. If you were to get a an omitted assessment on a 2025 warrant and you come to us in 2026, you'd have to file a certificate of error. You can no longer appeal those omitted assessments on the 2025 warrant. We mail notices of all of our omitted assessments that are issued, just like we mail notices in tri-towns for the general assessment year. Those notices are mailed to the address for the taxpayer, as we can discover from the public records. We really are very limited with information that we can use to locate to whom the notice should be mailed. Typically, our protocol is to look at the most recent deed in the chain of title and identify where the mail tax bills to address is showing on that deed. And that is, so that's the address that we would use that we enter for the omitted assessment notice. The notice will also tell you what your new assessed value is, and as well as what the deadline is to file your appeal for that township. One of the common defenses that's also outlined in this Rule 22 is how to make your bona fide purchaser defense, and I'll go into that a little bit more here. There is actual and constructive notice as determined by the courts in Illinois. As I mentioned, it's a common claim that taxpayers make as a defense to the issuance of an omitted assessment, but a bona fide purchaser is defined within the property tax code. Ownership is used in this section, as I've highlighted here, is held to refer to bona fide legal and equitable titles or interest acquired for value and without notice of the tax, which is the key language. So a bona fide purchaser is somebody who purchases for an interest for value and without notice. And as I mentioned, there are two types of notice, actual and constructive. Of course, actual meaning you actually know the certain facts that, as a prospective buyer about a property. And then there's also the constructive notice element to the notice requirement. And these are the circumstances or facts that a prospective buyer is chargeable with knowledge, and which imposes basically a duty of inquiry on the purchaser of a property. So all of the facts about a property really can be discovered through a simple FOIA request to our office, to the county clerk's office for recording documents. These are all public record and can easily be discovered. So my practice pointer here is really if you are an attorney who represents buyers and sellers in real estate, and specifically if you're the purchaser, you'll want to know exactly what it is that your client is purchasing in order to appropriately advise them of any of the consequences or the property tax consequences of that transaction. So when are omitted tax bills issued and when are they due and payable? So omitted tax bills are issued at first installment time every year. This means that you're getting them right away at first installment time, and but the good news is that they're not due until second installment time. As good news can come and go with these things. But that's how the property tax bills for omitted assessments works. Statutory interest applies to omitted tax bill just same way that it applies in a general assessment property tax bill. It's 1.5%. Well, at this point, after TY 2023, it's 0.75% per month. But if it's for a tax year prior to that, it reverts to the 1.5% per month tax. And then, but unique to omitted assessments is that there is a 10% penalty, if you will, interest. It's applied to the tax year that's 2 years after the time the first correct tax bill should have been received, which basically just means that if we issue omitted assessments in 2025 and we're back taxing all the way to 2022, that 2022 tax year is going to get 10% interest automatically applied to that tax year. So tax exempt properties. The Illinois Department of Revenue is the sole entity that is authorized to determine whether a property is exempt in whole or in part from taxation. We basically do what the Illinois Department of Revenue tells us to do. We apply the exemption as the Illinois Department of Revenue tells us to apply it. They'll issue a letter. They will issue a letter to the taxpayer that applied for the exemption. you know, let them know if it's either fully or partially exempt. And although we do often get these copies from IDOR, it's really better course is really to make sure that we get a copy of it if you want us to apply that exemption for you. And there's an email address here that you can send your IDOR letter to. On partial exemptions, you can file an assessment appeal on the non-exempt portion of that property and argue, you know, a reduction in the market value, assessed value, as you would with any other property tax appeal, and those and using the same evidence that we've already gone through in this presentation. Taxable leaseholds. Taxable leaseholds, of course, are a term of art, and those really refer to the leaseholds that are spaces leased out by either, you know, taxing districts or government agencies. And when we are reviewing or when we are valuing these taxable leaseholds, well, first we have to review the actual contractual agreement between the lessor and the lessee to determine if it is in fact taxable. In some cases, it may not be taxable, and that's controlled by the terms of each individual contractual agreement. When we do review or when we do assess a taxable leasehold, we are complying with the principles announced by the Supreme Court in the Corzine versus American Airlines case. So it's really important that we get a copy of that lease so we can review it and make a determination as to whether or not it is taxable. So the most current copy of the lease, and of course any other amendments to it, we will need, and those can be provided to us online using our smart file application. So Gina,
Yes.
it's your turn.
All right. So Rule 25 deals with the corrections of factual errors. And these are things, like I mentioned before, building square footage, building quick characteristics like number of bedrooms, number of bathrooms, things like that. Pin prorations, when a property is across more than one pin, sometimes a proration is incorrect. So that would be a factual error. Property classification, transcription errors, other errors in assessment due to reasons other than a mere difference of opinion and valuation. So, you know, a factual error, basically. You can contact us for corrections and factual errors at any time. Rule 25 tells you how to do that. We have multiple methods that you can contact our office, including email, mail, in-person video visits. We have a contact us section on our page, and you know, also we have we look at social media all the time. So, you know, there's a lot of ways to get a hold of us. Just be sure you include any and all documentation supporting your request for correction. If the number of bedrooms is wrong, try some building plans. That helps a lot. Surveys help, you know, with square footage issues. So just basically bring in documentation that best shows why the information we have is incorrect, and then we can work on correcting it. And next slide. For property location corrections, just so you know, it is the municipality rather than the assessor's office that determines the address for any property within its boundaries. So let's say you live out in Barrington. It'll be a municipality in Barrington that, you know, determines what your address is, and not our office. However, we have humans who work here, so that's why we sometimes have key punch errors, transcription errors, and also sometimes we have the incorrect property location address in our website. Basically, we ask that you handle these via the appeal process, and Rule 26 gives pretty explicit instructions on how to do that. So, you know, there's various places in Smart File to click and all that good stuff. Include information that shows what the address is. One thing that often helps, you know, if it's simply like, you know, you're at 1031 Sawyer Avenue, but we have 1032, take a picture of the front of the house. It shows your numbers. That helps. But there's a lot of different ways you can do that, just so it fits with showing what the address is. However, and this is the next slide, we can only update the property location addresses in our system prior to the certification to the Board of Review. Once we certify to the Board of Review, we have to wait until the next assessment year next assessment cycle to do so, because we don't want to mess up county data back and forth. We want to keep the assessment data associated with the PIN correct and not mess it up because of address changes. Hopefully someday technology can fix that, but right now we don't. But right now it doesn't. And also, we cannot update the mailing address on a property tax bill. If your property tax bill is being mailed to the incorrect address, it is the Cook County Treasurer that can control this. And they have this great website that you can go to and update that information online. You can do it from the comfort of your own home. I guess you could go in if you wanted to, but if you can do it from the comfort of your home, why not? So this gives the URL to correct that error. And next one, certificates of error. So section 1415 of the property tax code covers certificates of error. I'm not going to read it because it's a statute. You know, nobody wants to hear me read it word for word. Basically, C of E's can be filed as either a current year assessment appeal, and this is the next slide, the current year assessment appeal, or as a standalone. Rule 27 gives filing instructions for each. Filing it with your current year appeal is highly recommended because it makes it much easier for you to track, for us to track, and it eliminates double docket issues that might be caused by two different filings, even though they are for different tax years. C of E filings should be submitted with the same types of supporting evidence as a current year appeal. So let's say that you believe that our 2021 assessment is incorrect and based on your purchase price. So you would go to the purchase price rule and see, okay, what documents do I need to submit? Look up that rule, get those documents together, and then use that to support your C of E request. C of E filings without supporting evidence are unlikely to succeed, as are C of E for tax years which are pending at PTAB or circuit court. In the next slide, I will go through why that is. Okay, so the property tax code sets out the progression for an assessment appeal. The assessor's office is the first appeal, and the appeal at the assessor's office is actually optional. You don't have to appeal with us. It helps a lot to get your problems resolved quickly, or you know, earlier in the assessment process, and also if you have factual errors that the assessor can, you know, fix that later levels of appeal cannot. So it's a good idea to appeal with us, but you can appeal to the Cook County Board of Review, which they are the correct and proper form of appeal for assessor appeal decisions. If you disagree with our appeal decision, you can go to the Board of Review. Also, the Board of Review, you have to appeal there if you intend to go for further appeal from there at either the Property Tax Appeal Board or Cook County Circuit Court. You have to file at the Board of Review to do either. You can only file at either the Property Tax Appeal Board or the Cook County Circuit Court your tax objection. You can't do both. The proper way to appeal your Property Tax Appeal Board decision, if you disagree with it, is to go on for administrative review, or from circuit court decision on up to appellate court. What the property tax code does not really provide for is then what some people try to do is then file a C of E basically to appeal your Property Tax Appeal Board decision. You can't really do that. And so that's why if you do a C of E for both, you can't really get a dual remedy from both PTAB and the assessor for a C of E. And next slide, please. And also, if you filed an appeal with the Board of Review for a past tax year that you're trying to get a certificate of error for, and we determine that, oh yeah, okay, we'll grant this certificate of error, we have to provide it to the Board of Review for their review and approval too. So it's not just us that would decide on it then. The Board of Review gets to look at it as well because they're a higher agency. And also, if the assessor's office recommends a reduction in the assessed value of $100,000 or more, the certificate of error must be adjudicated in the circuit court. However, it's not like we just run over to court immediately. It's that's not the way the property tax code allows for it to be done. It's got to be done as an objection to the tax sale. So let's say 2023, we grant a certificate of error, or we think a certificate of error should be issued that reduces the assessed valuation by $150,000. That's great. That seems like yay for you. However, you'll have to wait until after the 2023 tax sale occurs before we can even take it to court to adjudicate this. And then these last 2 points, we've really already kind of covered it. You cannot really appeal your PTAB or tax objection decisions via C of E to the assessor's office. And next is the filing deadlines. The received wisdom had always been the past 3 years. Well, that always worked okay up until COVID, and then COVID delayed when the tax sales occurred. So now we are in a strange position where we can go back a few more years than just 3. And that's because the deadline is based on the date of judgment for the annual tax sale, rather than just being 3 years. Our office does track these dates rather closely so that we do know when we need to stop with the certificate of error granting them because a tax year might be expired. And as those practitioners who represent condominium associations know, there has been some recent changes in section 1415, and I'm going to turn this over to Tasha now to explain that further.
Back. Okay, so yes, on the C of E subject, there was an effort to gain the ability to go back further. So, you know, the 3-year C of E has been in place for some time, except for with exempt properties, which can go back 3 years from the IDOR decision. But here, you know, we had seen some cases and some practitioners had brought some things to our attention involving common area. And if something is really meets the standard for common area under the property tax code and or the Condominium Act, then the thought was, shouldn't we be able to correct it? And we simply had no vehicle to do so. And so the effort was made by others to initiate a change to the property tax code and allow that to go back much further. And so now the one can go back the 20 years and there's another provision that's not on here, but it specifically references 2004 and forward, but going back the number of years that are collectible for that time in order to correct the assessment of that parcel to $1. And the reason is there's also, we understand that with a common area, the value of that common area really should be built into the assessment of the other properties that are units or part of the planned development, because that is supposed to be built into that assessment. So in terms of correcting it back to that $1 makes sense. So take a look at those updates and know that that's something that if you didn't yet know, that could be helpful to your clients. Okay, so I alluded to this, but the property tax code, the same section addresses the C of Es for exempt properties. And those are the ones that, like charitable, educational use, those sort of exemptions, not subject to taxation for all or part of the property, that those can go back for the 3 years prior to the date of the IDOR letter. And then, of course, there's other means for going back further, but not at the assessor's office. There's court proceedings that can handle those prior years, but that's what the statute allows. And I know the current year of the IDOR letter, we need to have that, and people are good about bringing that into us, but typically the treasurer works with the year of the letter, and then we work with those prior years with C of Es and going forward. Okay, so you've been listening to us talk for some time. I think this is the time where we just want to wrap it up briefly. But just remember a few things from today's presentation, and that both taxpayers and representatives should review those rules and any helpful guidance that the guidelines provide, as well as those rules. But the rules have been changed, but partly to be organized and read easily, to be able to follow the information well. But we provide information to help you do what you need to in filing an appeal for yourself or for someone else. And kudos to Gina and Christina, who did a lot of work on the rules this year. Current assessment appeal should be filed timely within the window for the appeal that is posted on our website. We always post those dates, and we can't accept early or late appeals. So just keep that in mind. Watch for the township deadlines, and the calendars are updated regularly. Of course, as Gina mentioned before, you can also file at the Board of Review. So if someone did miss a date, that's an option, but just watch for those dates and you'll get your information in timely. The certain of the rules, 12 to 21, really are looking at evidence, the type of evidence that you're submitting, and we're trying to provide information that's helpful so that you can do a good job for your clients and we get the information we need for our team to make good decisions. Our website also has a lot of information, both how-tos, various subjects such as incentives, affordable, the data that's out there that Christina walked through some information earlier. So please do visit our website early and often. We are trying to make things information available. If you have additional comments about things that you think would be helpful, we'll see what we can do, but do take advantage of what's there. Reminder about some key policies that somebody else already covered: the vacancy policy, the cap rate policy, policies governing demolition and qualification of unimproved, how we categorize and classify unimproved property, and the timing of that, and the proration that goes on when improvements are removed. And then the policy regarding properties under construction. And I think you'll see also that we do welcome additional information. So, you know, we will be following these policies, but you may have nuanced information to give us that will prove helpful in our evaluation process. So please do that. All right, any questions? Of course, we've had the Q&A going, so I know some of those questions have been answered. And we'll open it up from there to see if there's additional answers that need to be made right now. But thank you very much for your time and listening to all of these subjects. And we hope that they are helpful as you move forward in the 2025 assessment cycle.
Thank you. And thanks to Rosa, our manager of legal services, and our senior legal counsel, Jerry Marconi, you know, behind the scenes, and also our director of residential valuations, Ray Gottner, and Brian Sibler, our director of special projects, commercial, for, you know, answering you guys' questions. Appreciate you guys jumping in to do that.
Jerry Marconi as well.
Yep, Jerry. Thought I mentioned Jerry. Yeah.
So
You
this
got me.
information will be posted online, the recording, and then of course the rules and information will be available online. Might stay on a few minutes just to answer a few more questions and then wrap.
Okay. I am going to go ahead and end the meeting. 1 second, I'm just taking a look at the questions.
You want to give us a few minutes so we can
Sure.
finish a few questions?
Yep. Okay. I'll give you a few minutes. That's fine.
Tasha, I was going to mention with the affordable housing, that statute's going to be amended this year. Right now, there's a look back period to 2015, and I think they're going to do away with that. So I think it's important, if people have clients that might qualify for it with expenditures going back to 2015, I would not wait. Try to get those applications in before that look back period gets taken out of the statute.
Thanks, Jerry. That's good for people to know. And then I won't give out their emails, but Anna and Eric are also available to address questions, not on today's meeting, but in the office about things related to affordable. It's an important one.
Okay, you guys okay with me ending?
Sure, we're just looking at some of these great questions and, yeah, quite a few questions here, but yeah, I think we're good.
Okay.
And Angelina, will that Q&A be available on the recording online as well? Because some have asked about that.
Yeah, I saw that and I really don't know the answer, which is why I can't say yes or no. Because I mean, the recording will be available, but I don't know if that includes the Q&A. I'm not quite sure. But I think there has to be a way I can access them, just if I needed to like put them in a PDF or something and add them. There has to be some workaround, but I'll have to look into it after. Okay, I'm going to go ahead and end because I think the questions just keep going. And we'll be here all night. But okay, we will make things available. We will add this video. We'll add the video to the website. The appeal rules are already there, and we'll add the presentation, and I'll see what I can do about the Q&A. Okay?
Great.
Thanks,
Thanks so
Angelina.
much.
You're welcome. Bye.
Bye.
Let me end this. I don't even know how.